A shareholders class action or a group litigation is when a group of shareholders get together to bring an action against a company for some sort of wrong. The English legal landscape hasn't really been fertile for group actions or class actions of this kind, unlike in the US, for example. But in recent years, I think probably a combination of factors have given greater stimulus to these sorts of actions. Legislative changes over recent years, such as the introduction in 2000 of the Financial Services and Markets Act, the advent of the global financial crisis and the resulting economic upheaval which drove shareholders to find means of recovering their losses. There's also the emergence of litigation funding and the need for funders who've raised significant amounts of capital to deploy that capital in pursuit of high returns. And finally, of course, innovative lawyers who are originating claims of this kind and actively pursuing action groups in order to bring them.
It's energy and natural resource companies that often bear the brunt of significant class actions. However, we have seen a number of significant claims before the English courts, which at their root have mass claims relating to the jurisdiction and duty of care of English parent companies and the extent of their responsibility for their overseas subsidiaries. Claims like Vedanta, which was recently before the Supreme Court and on which the judgment is awaited, will have a significant impact on the growth of mass claims or otherwise in the UK. We can see from the sorts of claims that have been the basis for mass action in Australia that there's every possibility, if not probability, that those sorts of claims will eventually be a feature of the UK legal landscape. It's entirely feasible that there could be claims brought against English companies in relation to the disclosure they have made about their future performance or their ability to cope with climate change regulation.
Shareholders' claims are being brought in more creative ways than ever before. They've never really been a feature of the UK market until really the financial crisis. What's become clear is as soon as there is a negative announcement, a regulatory finding which may be adverse to a public company, very quickly groups of shareholders are assembling themselves to bring those claims. We've seen it in the RBS rights action, we've seen it in the case of Tesco in relation to certain allegations regarding their financial reporting, and we've seen it most recently in the patisserie Valerie case where shareholders' claims are being threatened. Never before has it been easier to identify who the shareholders are in public companies. The information is publicly available. People have email addresses, people have websites. It's easier to put together the class that may ultimately end up bringing the claim against the public company. Globalisation is affecting the spread of shareholders' claims in certain unexpected ways. We're the largest litigation practice in the world, and that gives us a particular perspective about what's going on in different markets. And what we're observing is a claim that might start in California might spread to the east coast of Australia. It might then spread into Europe. And while the claims may all be framed in slightly different ways, what is clear is that they all have common origins and common fact patterns. For public companies that are facing these claims, they need to be aware of the possibility that this risk is real. They need to understand it, and they need to have in place a 360-degree strategy to mitigate the risk. And that means having in place a strong regulatory strategy based around robust compliance and governance, and when issues do arise, having in place an early stage pre-litigation strategy.